Alright, good afternoon everybody. We are at that point in the semester where we are slowly transitioning into contract law. So whether you realize it or not, you've probably entered into multiple different contracts with just in this week alone of your lives. If you signed an apartment lease, for example, that was a contract. Whether you accepted the terms or conditions on your iPhone, that was a contract. If you purchased something from Amazon, for instance, that transaction, well, that is also governed by contract law. If you bought a meal for your class today, then you entered into another contract. Banks issuing loans, that's a contract. Employers hiring just employees through contracts. Professional athletes, if you're playing for a soccer team, worth hundreds of millions of dollars. The University of Florida itself, relying on so many different contracts with just different faculty, vendors, publishers, and of course, the students. So in many different ways, modern society would just simply not function without its many contracts. But of course, this raises many different important questions that we need to go over today. So for one of these questions is that if every promise that people make were legally enforceable, then the courts would obviously be overwhelmed. So imagine telling your roommate, for example, I'll help you move this weekend, and then you decide not to show up. Well, of course, that's definitely inconsiderate, but the judge isn't going to order you to spend that Saturday carrying boxes, right? Likewise, if I were to just tell my buddy, hey, I'll buy you lunch next week, and then we forget about it, it's not going to be a legally enforceable obligation. So we're really looking at a much more deeper question than this. Specifically, when does the law decide that a promise is important enough to legally enforce? And that question has occupied the courts for centuries, and the answer of these forms is the foundation of contract law. So by the end of today's lecture, you should understand three essential elements that every valid contract requires, the situations in which a contract may be void or voidable, and of course several different landmark cases that we're going to go over that continue to shape American contract law today. So before we begin discussing contracts themselves, I want to briefly return to someone we've encountered earlier in the semester. At least if you've been reading the textbook, you should be aware of this. That person being Max Weber. So he was a German sociologist, and you might remember Weber from just being one of the founders of sociology, but he also had important observations about our legal systems and police legitimacy as well. So Weber argued that modern economies depend on what we call the calculability of the law. So in other words, just to simply explain this, businesses and individuals need to be able to predict with a reasonable degree of confidence how the court will apply legal rules. So essentially setting precedent, right? Again, an example here. Imagine if you're trying to just start a business and if the contracts were enforced only when the judges felt like enforcing them. If that was the case, would you be comfortable with loaning somebody, say, $100,000? Would you be comfortable investing millions of dollars in a new factory? Would the bank issue a 30-year mortgage if you're uncertain of the results here? Well, the answer is obviously probably not. In commerce depends on predictability. People need confidence that if they're making an agreement today, then the courts will be able to enforce that agreement tomorrow under consistent legal rulings. And this is exactly what Weber meant with the calculability of law. Now, notice something interesting here, that contract law isn't really about encouraging people to just simply trust me, bro. It's really about allowing complete strangers to do business with one another because they have to trust in the legal system. And that's the profound difference here. The law becomes the substitute for personal trust. And this idea also appears directly on your upcoming quiz, so pay attention. So overall, just keep these ideas in mind as we move forward throughout the semester. Okay, so now that we've discussed why contract law exists, let's examine what every legally enforceable contract must contain. So, despite the complexity of contract law, virtually every contract begins with three essential elements. First, there must be an offer. Second, there must be acceptance. And third, there has to be consideration. Now, if any one of these three elements is missing, then there generally is no enforceable contract in place. And just notice that nowhere on this list is the word money, right? People mistakenly believe that a contract always has to involve paying cash. They don't, so keep that in mind. You could promise to paint someone's house in exchange for fixing your car, and neither party would have to pay any money, yet both parties have exchanged legally sufficient consideration. Similarly, I could promise to tutor you in exchange for helping me move next weekend. Again, there is no money involved here, but there is still a valid exchange of promises. So the distinction is important because one of your quiz questions will be covering this. So again, just keep all of these things in mind. Remember that the three required elements are offer, acceptance, and consideration. And throughout the rest of today's lecture, we're going to be examining each of these three different elements individually through three appellate court decisions. And rather than simply memorizing definitions, you're going to actually get to see how real courts have resolved actual disputes and how these decisions continue to just shape modern contract law. So we need to begin with the first question that every court will eventually ask. Was there actually an offer made? So at first glance, this sounds relatively simple. Someone offers to sell something, for example, right? And someone else agrees to that offer. You would think that's the end of the story. Well, unfortunately, contract law is just rarely that simple. So one of the first questions a court has to ask was whether or not the offer was ever even made in the first place. So suppose I tell one of you after class, I've been thinking about selling my truck, all right? Have I just made you an offer? Well, no. But what if I said instead, hey, if you're interested, maybe I'd sell it someday? Well, it's still no, okay? So those statements that I just said there, that simply is the beginning of negotiations. They're invitations to continue talking about me potentially selling my truck in the future. Now, suppose instead I were to say to you, hey, insert person, I'll sell you my truck for $8,000, and you have until Friday at 5 p.m. to let me know. So now we've actually crossed an important legal line. That statement is sufficiently definite. In that statement, I've identified the property, the price, the offeree, and the time for acceptance. So that's what a contract law generally requires as an offer. So one thing that confuses students frequently is how the courts apply what's known as the objective theory of contracts. And this can be a little bit confusing because the question isn't really, what did the speaker secretly intend? The question here is, what would a reasonable person listening to these words believe, okay? And if a reasonable person would conclude that a serious offer was made, then the contract law generally treats it as an offer. And so this objective approach makes commercial transactions far more predictable because the courts evaluate outward conduct rather than hidden intentions, okay? And if you, in your reading supplement with Dr. Rivera's work, it explains to you that the test is what a reasonable person in the offeree's position would understand from the offerer's words and actions, not what the offerer secretly intended. And this will bring us to our first major case. Okay, so now we're getting into our first case of Normile versus Miller. Now, this case involved what appeared to be just an ordinary real estate transaction. The plaintiffs in this case, Normile and another prospective buyer, wanted to purchase a home owned by Hazel Miller. So, working through the real estate agent, they had to prepare just a written offer to buy the house, as you would. And importantly, the offer here included a deadline. So, Hazel Miller, Miss Miller, had essentially said that you have until 5 p.m. on August 5th to accept the offer for the house. So far here, everything appears to be pretty straightforward. But of course, like all good case law, things become a little bit more complicated. So instead of simply just signing the buyer's offer, Mrs. Miller changed several important terms here. So she increased the required down payment, she shortened the repayment period off the seller financing, she reduced the remaining mortgage balance, and she added a financing contingency requiring the buyers to qualify financially before any agreement became effective. But notably, Miller hadn't changed the expiration clause, so Normile believed that he had the right of first refusal until August 5th at 5 p.m. And Normile didn't give an immediate answer to the counteroffer that was presented by Miller. So Miller is essentially giving Normile a counteroffer, and Normile thought, hey, I still have until August 5th at 5 p.m., so I don't have to respond to this counteroffer until then. But following this, in the early hours of August 5th, before 12, this guy, Lawrence Siegel, swoops on in and essentially steals the offer for Miller's real estate, and she accepted it. So then Miller had to inform Normile essentially that the offer had been revoked because her counteroffer was sold by Siegel, who came and swooped up the property. And following these events, Normile ended up suing Miss Miller, leading to our case today. Now ask yourself this, did Miss Miller ever accept the offer that was presented by Normile? You could say, hey, well, she mostly accepted, but contract law just doesn't work on the word mostly. Changing the terms of the contract is extremely consequential, legally speaking, and that actually leads us into our next slide here regarding her counteroffer to Normile. When Normile sued Miss Miller, the court ended up concluding in short that Miss Miller did not accept the buyer's original offer, and instead she made what contract law calls a counteroffer. A counteroffer has two important legal effects you should be aware of. First, it rejects the original offer, and second, it creates an entirely new offer. Now, I'm just going to use a metaphor here as like a tennis match. So player A serves you the ball, and instead of catching it, player B hits it back. So then it's player A's turn again to decide whether or not they want to hit the ball back another time. The original serve is over, right? This is essentially exactly what is happening here with this counteroffer. Once the seller materially changed the proposed terms, the buyer's original offer ceased to exist. And this really illustrates what's often called a mirror image rule. Acceptance must mirror the terms of the offer. So if you materially change those terms, you haven't accepted, you've just proposed a different bargain. And the distinction becomes critical because only an existing offer can later be accepted. And once the original offer disappears, there's nothing left to accept. So in closing with this case, the North Carolina Supreme Court explained that there can be no contract unless both parties mutually assent to the same bargain. So, once the seller proposed materially different terms, the original offer was no longer open for acceptance. You could even just say you snooze, you lose, honestly. You didn't take up the original offer, somebody else was willing to go for that offer, so early bird got the worm, I guess. But this case does teach us just several foundational principles that appear repeatedly throughout contract law. First, an offer must be sufficiently definite. Second, the courts have to apply an objective standard when deciding whether or not an offer exists. Third, a counteroffer rejects the original offer and creates a new one. And finally, there can be no contract unless both parties mutually assent to the same agreement. And likewise, if a buyer attempts to accept an offer after it's already been replaced or terminated, then the courts will generally not enforce the contract because there's no longer an offer capable of being accepted. So now that we've established there has to be a valid offer for a contract, we're arriving at the second essential element of every contract, and that is acceptance. So at first glance, like I've said before, acceptance is really straightforward. Someone makes you an offer, someone else says, hey, I accept that offer, boom, you get a contract formed. So most contracts work exactly this way. If I were to offer to sell you my laptop for, say, $500, and you immediately respond, I'll take it, then we have formed a contract. But of course, not every contract works this way. We have both unilateral contracts and bilateral contracts. So the distinction here is that a bilateral contract is the type of contract that you're more familiar with. It's consisting of a promise exchanged for another promise. So for example, if I were to sell you my truck and then you promised to pay me, say, $8,000, well, we've both become legally obligated immediately after exchanging these promises. But with a unilateral contract, this is different. Here, it's only one party making a promise, and the other party accepts only by performing the requested act. So for instance, if I were to put out flyers for my dog Louie and say, hey, I will pay you $1 million if you find my sweet bulldog Louie. Well, no one's obligated to look for my dog. But if they do perform the requested act by finding and returning Louie to me, then the offer has been accepted through the performance of them looking for my dog, right? So the question that we're going to be asking in the upcoming case we're looking at here is, what happens if someone begins performing under a unilateral contract, but the offerer changes their mind before the performance is completely finished? So in our second case involves the plaintiff, Mary Ellen Cook, a successful real estate agent working for Coldwell Banker in Missouri. Her employer announced a bonus program designed to encourage employees to remain with the company and generate higher sales. The program contained different bonus levels depending on the amount of commissions an agent earned during the year. The more commissions that, say, Miss Cook earned or any other agent generated, the larger year-end bonus for them. So Miss Cook immediately went to work. She continued selling homes and ultimately earned enough commissions to qualify for one of the highest bonus levels, so everything seemed to be according to her plan here. However, before the bonuses were paid, the company changed the terms of the program. So Coldwell Banker now claimed that employees would have to remain employed through a year. So Coldwell Banker now is claiming that employees would essentially have to remain employed through a later date in order to receive their bonuses. But Miss Cook had already generated the required commissions, but resigned before satisfying the company's newly announced condition. So due to her resigning, the company refused to pay her, and naturally she filed suit. Now ask yourselves, if you had spent months working towards your promised bonus, should your employer be allowed to just change the rules after you've already done the majority of the work? Well, that's exactly the issue that falls before the Missouri Court of Appeals in this case. So the Missouri Court of Appeals sided with Mrs. Cook. The court actually explained that the employer's bonus program constituted an offer for a unilateral contract, and unlike the bilateral contract, Miss Cook did not accept anything by making a promise. She accepted by performing. She did her end of the deal. So specifically, when she had continued working and generated enough substantial commissions, she did exactly what Coldwell Banker was stating that the bonus program encouraged employees to do, right? So The court is essentially emphasizing an important principle. A promise to pay a bonus in return for an at-will employee's continued employment is an offer for a unilateral contract that becomes enforceable when accepted through the employee's performance. So notice what the court did not require here. It wasn't insisting that Mrs. Cook had to complete every conceivable condition before receiving any legal protection. Instead, the court was just simply recognizing that, hey, Ms. Cook had already provided substantial performance in reliance on the employer's promise. So, in other words, she had done enough to substantially perform under the agreement, and the employer could not just simply revoke the agreement or change the offer and avoid paying the promised bonus. Now, to appreciate why this case matters, I think it's helpful to compare it to an older case that many law students study during their first contracts course. So this case that I'm referring to is Peterson v. Patberg. So in the case of Peterson, the defendant promised to forgive part of a mortgage that if the borrower had paid it off by a certain date, and the borrower appeared at the defendant's home with the money in hand, but before the borrower could actually hand over the payment, the defendant revoked the offer. So the New York court held that the revocation was effective because complete performance had not yet occurred, and Dr. Avira's supplemental work summarizes the old rule in this way. So an offeror can essentially withdraw the offer at any time before the request to act has been fully completed. Many people view that result as a little bit harsh, understandably so, but Cook reflects the more modern approach of this law. Rather than just focusing exclusively on the complete performance, many courts now recognize that once a promise has been substantially performed in reliance of the offer becomes enforceable. So the shift better protects fairness and prevents one party from changing the rules after receiving most of the benefit of the bargain. So overall, the case of Cook just teaches us several different important principles that you're going to see again throughout contract law. So first, acceptance does not always require spoken or written words. Sometimes acceptance occurs through conduct, like Mrs. Cook's work. So second, unilateral contracts become enforceable through performance. Third, many modern courts recognize substantial performance is sufficient enough to enforce a unilateral contract. And last but not least, courts often seek to prevent one party from unfairly benefiting after another party has already relied on a promise. And this case also appears directly on your quiz, so make sure you know this stuff. So we've now examined the first two elements of a valid contract, offer and acceptance, and now we've arrived at the third, consideration. So many students initially believe that consideration simply means money. To be very clear, it doesn't. Instead, consideration refers to something of legal value exchanged between the parties. So that something could certainly be money, but it could also be just something like performing a service, transferring property, making a promise, as we've talked about earlier, or even refraining from doing something that you have a legal right to do, right? So say refraining from smoking or drinking until a certain age, or undertaking some of other legal obligation. So the important part here is that both parties must exchange something of legal value. And the courts are generally not going to ask whether or not the exchange was wise or if the bargain was fair. They're not going to ask whether or not one person received a better deal. Instead, the courts will look to a much narrower question, and that just being, was there consideration, right? So that distinction is definitely critical because contract law values freedom of contract, and as an adult, you're generally free to make good decisions, bad decisions, good bargains, mediocre bargains, or even terrible bargains if you so choose to. So the courts, they're not going to try to rewrite the contract simply because one side had a better deal, right? Or if somebody regrets the deal later on. And our next case illustrates this point quite well. So to understand this case, we have to briefly step back into history. The events occurred during World War II when Greece was under Axis occupation. The country experienced a severe economic collapse. There were food shortages that were just widespread. There was a lot of inflation. Many families simply struggled to even survive. And so much of this hardship was just owed in great part to the Nazis' destruction, as they plundered so many different crops, and it just resulted in a very widespread famine throughout Greece. So many of the civilians just couldn't even survive. And that actually brings us to our main character of Eugenia Demotsis. So essentially, Demotsis at this time, like many other people, couldn't really survive on her own. So she asked George Batsakis for money to feed herself and her family. So Batsakis ended up agreeing and offered to loan her 500,000 Greek drachmae, and she would repay him $2,000 at 8% interest. Now, this sounds like an enormous amount of money, but because of the wartime inflation, the currency's actually value is relatively small, roughly equivalent to about, say, $25 in US currency at the time. Now, think about this deal for a moment here. She's receiving the equivalent of about $25 $25, and she's promised to repay nearly 8 times that amount, okay? So this is obviously extortion. But after the war ended and she actually regained access to many of the assets she had, Mr. Batsakis sought repayment from Demotsis. And of course, Miss Demotsis refused. She argued that the agreement should not be enforced because the consideration she received was grossly inadequate. So in other words, she's essentially claiming that this was such a terrible bargain that no court should enforce it. And if you read, obviously, Rivera's supplemental materials here, the discussion also reminds us of why she accepted that agreement in the first place. Like I said, just keep in mind the different factors in place here of the wartime famine, and the loan might have been sufficient enough to obtain food or necessities in the black market, but making it far more valuable in that moment than its face value alone might suggest. So now you have to ask yourselves this: should the court rescue someone from a bargain that seems incredibly one-sided? So in closing, the Texas Court of Appeals answered this question with a clear no. The court enforced Eugenia's contract with George. Now why is this? Well, this is because the issue is not whether the bargain was fair or economically equal. The issue was whether simply or not the legal consideration existed. And we know that Ms. Demotsis admitted that she received exactly what Mr. Batsakis had promised to give her. So she received the money, she voluntarily signed the agreement, and she promised to repay the larger amount. So this was enough in order to create an enforceable contract. It doesn't matter how unfair it was. The court famously stated that the more inadequacy of the consideration will not avoid a mere contract. So think carefully about what this means. The courts don't distinguish between just no consideration, which can make a contract unenforceable, and inadequate or bad consideration, which will generally not invalidate an otherwise valid contract. I mean, these are just not the same thing. So, for example, if I were to agree to sell you my car for $100, that might seem like a terrible bargain, but it's still a consideration because both parties exchanged something of legal value. So bringing it back to Batsakis v. Demotsis, in this case, the court was not just deciding whether or not Mr. Batsakis behaved fairly by charging such a high repayment amount. Instead here, the court is only asking whether or not an exchange occurred, which it absolutely did. And since Mr. Batsakis provided the money he had promised to Ms. Demotsis, and Ms. Demotsis had agreed to repay all of this money, the contract was enforceable under Texas law, and the court refused to just rewrite the parties' bargain simply because one side later appeared to have made a poor deal. Now, the case of Batsakis is definitely important because it really just shows us the courts are concerned with the existence of consideration and not the adequacy of the contract itself. With this said, though, I mean, while many contracts are unfair and they can still nevertheless be legally enforceable, it doesn't mean that courts can ignore unfairness altogether, okay? So, for instance, if someone had obtained a contract through fraud, or threatened violence, or exploited someone that was lacking legal capacity, then the result will be very much different, and these doctrines address how the agreement was formed. But with Batsakis, it's just teaching us that courts will generally just not invalidate a contract simply because one side had made a bad bargain. So far today, we've assumed that both parties were legally capable of entering into a contract. But what happens if one of the parties lacks the legal ability to understand what they're agreeing to? So should the court still enforce that agreement? Well, contract law would generally say no. But before we discuss who lacks capacity, we need to begin with the important legal presumption. The law presumes that every adult possesses the legal capacity to enter into a contract. And think about why this rule exists. Imagine going out to buy some groceries at Publix. Would the cashier need to administer an intelligence test before selling you milk? Well, I would certainly hope not. Commerce would become impossible if that was the case. So instead, the law begins with the assumption that, compellent adults are capable of making their own decisions. But this does have an important consequence. Because capacity is presumed, the burden of proof falls on the person claiming incapacity. So in other words, if someone later argues, I lacked the mental capacity to enter into this contract, then the individual has to prove it. So the court doesn't begin by assuming incapacity. Capacity is always presumed, and therefore the person claiming incapacity bears the burden of proving it. And this is where we get into specific examples of void versus voidable contracts, because we need to distinguish the two terms because students just frequently confuse these. So these are not the same thing. A void contract is treated as though it never legally existed. The law simply refuses to recognize it. So for example, if two people enter a contract to commit an armed robbery or sell illegal narcotics, the court is not going to enforce that agreement. The contract is void from the beginning because the object is unlawful. A voidable contract, however, is very different. A voidable contract is initially valid and enforceable. However, one party has the legal right to avoid or rescind the agreement because of some defect in the contracting process. So think of it this way. A void contract is dead on arrival. It never existed. A voidable contract is alive unless the protected party chooses to cancel it. Now, when does the law permit someone to avoid a contract? Well, here are the three most common grounds: lack of capacity, duress or undue influence, or fraud. Now, notice what is not on this list: a failure to satisfy the Statute of Frauds. That's a separate issue concerning enforceability, and not one of the classic doctrines that makes a contract voidable. So contract law recognizes several categories of individuals who may lack legal capacity. First category is minors. So generally speaking, contracts entered into by minors are voidable at the minor's option. Now, why is this? Well, that's because the law seeks to protect young people from decisions that they might not fully understand. With this said, this protection does have limits. Suppose a 16-year-old purchases food, or rents a hotel room while traveling, or receives emergency medical treatment. Should the minor simply be allowed to refuse payment? Well, the courts say no. The law requires minors and similarly situated mentally incompetent individuals to pay the reasonable value of necessaries, such as things like food, clothing, shelter, and medical care. Otherwise, businesses would refuse to provide these essential goods and services to anyone under 18 or anyone with a diminished capacity. Now consider mental incapacity. Not every mental illness renders someone incapable of contracting. So the question is whether or not the person possessed a sufficient mental capacity to understand the nature and consequences of the agreement at the time it was made. Likewise, intoxication presents another narrow exception. Simply drinking alcohol before signing a contract doesn't make the agreement unenforceable. The intoxication must be so severe that the individual cannot understand the transaction or meaningfully manifest assent. And this is an extremely high standard. In practice, most intoxicated individuals will remain bound by the contracts that they sign. So when applying capacity in real cases, let's briefly look at two examples to illustrate how these principles operate. So the first is Dodson v. Schrader. A minor purchased a used pickup truck, and after driving it for some time, the truck deteriorated and suffered damage. Now, when the minor later sought to rescind the contract, the court faced an important question. Should the minor recover the full purchase price even though the vehicle had been used and depreciated? Well, the Tennessee Supreme Court said no. Where the transaction was fair, there was no fraud or undue influence, and the seller had acted in good faith, and the minor could rescind the contract, but still had to compensate the seller for the depreciation and the damage caused while using the truck. And this prevents minors from using the doctrine of incapacity as both a shield and a sword. A second example of capacity is in Hauer v. Union State Bank. In that case, it just involved a person whose mental capacity was seriously impaired. The court emphasized that contracts entered into by the mentally incompetent individuals should be rescinded under appropriate circumstances, particularly where no other party knew or had reason to know of the incompetence. So at the time, the courts also had to consider whether the parties could reasonably be restored to their original positions before undoing a contract. Now, taken together, these cases just remind us of the capacity doctrine that's designed to balance the two important goals. On one hand, of course, we want to protect vulnerable individuals from exploitation, but on the other hand, we do want to preserve certainty and fairness of those who enter contracts in good faith. So as we move into the next topic, we're going to be examining situations where a person does possess legal capacity, but their apparent agreement is nevertheless defective because their consent was improperly obtained. So in other words, our next question is not, could this person legally contract? Instead, it's just looking at, was the agreement truly voluntary? And that question takes us to the doctrine of genuine assent. Up to this point, we've assumed that both parties voluntarily entered into agreement, but contract law asks another important question. Did both parties genuinely assent to the contract? So in other words, was the agreement truly voluntary, or was someone's apparent consent obtained improperly? So even if a contract contains an offer, acceptance, and consideration, all of which we've gone over, and let's say we have legally competent parties, the contract can still be voidable if genuine assent is lacking. So the three most common reasons for this are things like duress, undue influence, and fraud. Now notice something interesting. These are the exact three doctrines we introduced when discussing voidable contracts, and now we're finally going to define them. So let's begin with duress. Duress occurs when someone is forced to enter into the contract because of an improper threat that leaves them with no reasonable alternative. Many people think duress only means someone holding a gun to another person's head, and while physical threats definitely qualify, courts do also recognize economic duress in limited circumstances, and one of your assigned cases actually explains this principle. In Totem Marine Tug and Barge, the Aliska Pipeline, the court recognized that economic pressure, particularly when one party exploits another's financial vulnerability, may be sufficient to render a contract voidable. Now, the lesson isn't that every difficult financial decision amounts to duress. Rather, that courts have to examine whether or not the pressure became so coercive that the party no longer exercised meaningful free choice. Now, compare that to undue influence. Unlike duress, undue influence doesn't rely on threats. Instead, it takes place when one person takes advantage of another person's weakened mental or emotional condition. And one of the leading cases for this is Odorizzi v. Bloomfield School District. The court had to explain that a dominant party applied excessive pressure to someone whose weakened condition made them unusually susceptible to persuasion, which resulted in Odorizzi signing the agreement, which was later on rescinded. So the common theme here between duress and undue influence is pretty simple. The law has to protect genuine choice, and when the genuine choice disappears, the contract can become voidable. Now let's jump into fraud. Fraud occurs when one party intentionally misrepresents an important fact, another party reasonably relies on that misrepresentation, and then obviously there is a harm suffered as the result. Now courts generally require several elements before allowing a contract to be rescinded for fraud. A plaintiff must prove a material misrepresentation of fact, that the statement was false, that the speaker knew it was false or acted with reckless disregard for its truth, and that the other party relied upon this statement and that the reliance caused the injury. However, contract law also recognizes an important limitation. Not every exaggeration constitutes fraud. Suppose if I were to tell you, this is the greatest used car you'll ever own. Is that fraud? Well, probably not. That's what lawyers would call puffing. It's an opinion, compared to saying that this car has never been in an accident, right? Well, I know that I totaled my car last year, so now we've moved from an opinion of the best car ever to a false statement of material fact. Always check the Carfax, kids. It's important. But the type of conduct that might justify rescinding a contract has to be materially false in nature. So remember that an opinion is generally not fraud. False statements of material fact can be. So now let's discuss another important question. Must the agreement be in writing? Most contracts do not have to be written. You've probably entered verbal contracts at least every week. However, certain categories of agreements carry such a high risk of fraud or faulty memory that the law requires written evidence. So this doctrine is known as the Statute of Frauds. Although states definitely differ with this, you guys should just remember that the major categories commonly require a writing. So the contracts involving the sale of land, agreements that cannot be performed within 1 year, certain promises to answer for another person's debt, promises made in consideration of marriage, and the contracts for the sale of goods governed by the UCC, Uniform Commercial Code, above a statutory threshold. Now, notice why this doctrine exists. It's not because oral contracts are inherently invalid. Rather, it's because writing requirements help to prevent fraudulent claims regarding important agreements. Now, finally, let's briefly discuss one of the most influential developments in American contract law, the Uniform Commercial Code, as I referred to earlier, the UCC. Now, before the UCC, states often applied different rules to commercial transactions. Businesses operating across state lines faced considerable uncertainty. Now, the UCC was designed to promote greater uniformity with this law, but today every state has adopted some form of the Uniform Commercial Code. It governs many of just the important commercial transactions, including things like sales of goods, commercial papers, secure transactions, and numerous aspects of commercial contracting. Now, the broader lesson here is that the UCC promotes predictability, which brings us back full circle here to the beginning of the lecture that I was talking about Max Weber's idea of the calculability of law. Now, in closing with today's lecture, if you remember all of the principles and things I've taught you, and most importantly, you understand why the courts reached the decisions they did in cases like Normile, Cook, and Batsakis, then you'll definitely be prepared for the quiz, but you'll also have a solid foundation for just thinking about why contract law works the way it does, and why lawyers and judges have to think the way they do when evaluating these different contracts. But with this said, I conclude today's lecture. I thank you, and I'll see you next time.